And again, congratulations to all the winners of those great recognitions in SETI, particularly who I've known for a little while as well. And hopefully everyone's enjoying their lunch. I am thrilled to be here, and I am not a state solicitor general. But there is a connection that I have to that world. For the last 30 years, I've, in my practice, largely focused on state attorneys general. I run the practice at Jones Day. I chair our financial institutions practices there as well. And so I find myself regularly dealing with state attorneys general who, in the last 20, 25 years, have really started to build a group of lawyers that now has turned into a group of over 38, I think, states that have state solicitor generals that have varied roles and functions that they serve for the states. I think it's particularly poignant that this group takes some time to recognize what's going on in the world of state solicitor generals, because when you look at the news and you look at the headlines, in virtually every one of those situations, you're going to find over the next few years and certainly over the next decades that state solicitor generals are at the core of trying to define what the rule of law is going to be in each of our states, and ultimately the relationships with the states and the federal government on a number of the public policy issues we have and day-to-day nuts and bolts issues that we have. And for SABA, I think you're going to also find that the people that make their way through this real important position of public trust and of public service exhibit the kind of culture, persistence, and professionalism and passion that all of us should feel whenever we enter the world of not only doing what we do as professionals, we enter into as part of being in the legal profession, but also what we should be doing for those around us. I want to take a little bit of time to introduce who we have on the panel and some of the things we're going to discuss, but it's also important to think about why state solicitors general are important to what is going on today in the states. As you know, every state has, and the District of Columbia, where Loren is, has a state attorney general, and those roles and responsibilities and areas in which those state attorneys general have chosen to get involved in have changed dramatically over the last 20, 25 years, particularly because of the jurisdiction that they have established based on things that they've done individually within their states, but also collectively. So we're going to talk a little bit today, not only what's going on in these individual states as important public policy issues, but also what's going to happen as part of their collective action. I think probably some of you in your roles have been involved in multi-state attorney general investigations or actions. As the folks up here know, there's not really any such thing that exists under the laws or any formal rules that go along with it. It is a creature of the collaborative nature that states have developed in trying to address issues that they feel they can address better, perhaps in many situations, than could some of the federal structures that exist right now. I'll be careful with my words because I think that we're going to be able to get into some other issues that are a little bit more interesting than my introduction here. But let me tell you who we have on the panel, starting from the far end. Loren, AliKhan, who I'm sure many of you know, is the Solicitor General for the District of Columbia and has worked in that position now since 2017, has been Deputy Solicitor General before that, starting in 2013, worked at Melvany in their appellate practice before that, and has a slew of recognitions before that, including having worked in the United States Solicitor General's office and the academic credentials that go along with it. Loren's going to share with us some of the thoughts from her office, but also what's interesting is her Attorney General Carl Racine, who some of you may know as well, who is a very active, well-known, and whose face you see on TV a lot with a lot of the recent issues that have come up not only in D.C., but also ultimately with this current administration. To Loren's right is Andrew Pinson. I will not refer to the fact that Andrew used to work for me at Jones Day as an associate in the Atlanta office of Jones Day, but is currently the Solicitor General for the state of Georgia. Andrew not only distinguished himself by being a good Georgia fella, having come through University of Georgia, was a Supreme Court clerk for Justice Thomas, came to Jones Day and has certainly distinguished himself in the solicitor's office and has a number of great things coming up as well. We have Andrew up here for diversity purposes. I'm sorry, was my mic still on? To Andrew's right, and I don't know if I can be much more, do much more than the introduction that Amit got in getting his award, and congratulations to him again and to his wife for the work that they've done. But also, in addition to now being the Solicitor General for the state of Florida, Amit has also distinguished himself, as you heard before, as being a former Supreme Court clerk and having worked in a number of other impressive positions in Florida and elsewhere. One of the things I want to make sure we do today, in addition to putting them in difficult positions and answering questions, is sort of figure out first what draws people, particularly from our communities, to take on such significant public roles and public service roles. And I find that this kind of position is one that draws a lot of attention, but also is one that requires incredible amounts of professional discipline because of the rule of law that has to be forged in what they do on the appellate side, but also on their work that they do with their colleague and boss, who would be the state attorney general. That changes over time, and policies and other highlighted issues will come up there. So let me first start by asking the simple question: why did you want to be a state solicitor general? I mean, I'm not sure if everybody even knows what they do, but something drew you to it. I'll start on the floor. Let me start with Loren.
Sure. Let's see, why did I become a state solicitor general? I had been doing appellate litigation for about a decade, and I had been in and out of government service, and I knew that I wanted to return to government service from private practice, and the state solicitor general role sort of offered the ability to be at the front lines of both litigation and public policy, and to do so at a very local level. Prior to being at O'Melveny, I'd been at the Justice Department working on issues that were national in scope, but I had lived in the district at that point for, nearly 15 years, and I wanted to give back to my community. I wanted to get a sense of what the laws were like on the ground. And so coming into the role of first the Deputy Solicitor General and then the Solicitor General, I really got to have an impact on litigation and policy at the minute detail level of the community in which I had spent so much time. But for those of you that might not be familiar with the state solicitor general role, solicitors general are the chief appellate advocate for the state. So I am the solicitor general for the District of Columbia, and in that capacity, I represent the district before both the local and the federal courts. So predominantly that is the DC Circuit, the DC Court of Appeals, and the US Supreme Court. But we are also often before the Fourth Circuit. And then as Tony mentioned, there are a lot of multi-state coalitions that involve us in litigation throughout the country. And so, yes, I think I came to the role because I wanted to be in public service, and I wanted to do so at a very micro level.
Great. Andrew?
Sure, yeah, as Antonio joked, not everyone even knows what a Solicitor General is. I was in that boat until sort of a couple years out of law school. I had never heard of the role or really knew that it was out there. Coming into my clerkship with Justice Thomas, I started seeing these Supreme Court arguments, and the states would be represented pretty typically by Solicitors General. And I was like, oh, so that's a thing. And a very interesting thing that you have sort of this point person at the state doing appellate work at the highest levels. And by that time, I had sort of identified appellate practice as something that I was interested in. It's a difficult niche to find in private practice, frankly, developing an appellate practice outside of certain specialties. And so that drew me to it. And then I think, as much as anything, we spoke a little bit about this before in preparing it. It really offers an opportunity for a lot of people who maybe gravitated to DC or New York or other places to end up going home and to do good work for your state and the people of your state. And that was a lot of what eventually drew me to the role. I went back home after I was in DC for about 3 years and was at Jones Day for about 2.5. And then at that point started looking for public service opportunities, and this is one that came up. So that's sort of my path there, and I think it's definitely an interesting niche for someone interested in appellate work who wants to do public service in that kind of vein.
Great. Amit?
Yeah, I would echo all the reasons that Loren and Andrew offered, and just maybe a little bit on a more personal note. I can tell you, I can remember the exact time when I first started thinking about the possibility of being not just a state solicitor general, but actually U.S. Solicitor General. Now, for those of you who know me, you may think, gosh, it's kind of incredibly arrogant for someone who's so palpably underqualified to even be thinking about the prospect of becoming U.S. Solicitor General. And no, I'm not disagreeing with you if that's what you're thinking, but hear me out. So it's the spring of 2009, and I'm working as a humble attorney advisor at the Office of Legal Counsel at the Department of Justice. And doing what you do, you put in a lot of late hours in that job. And so I'm working, I think it's probably at close till midnight one day, reviewing these documents, and I'm walking out of a secure facility, having kind of finished my night's work, and a security guard approaches me. And he says, "Excuse me, sir," as I'm exiting the building, he says, "Excuse me, sir, but could I please have your autograph?" And I'm looking around me like, you've got to be talking to someone else, right? Like, that can't possibly be me, and there's nobody else around me. So I ask him, I'm like, "Excuse me, what was that?" And he repeats the question. He says, "Well, excuse me, sir, could I have your autograph, please?" So now I'm starting to feel pretty good. I'm thinking, yeah, I do work hard around here, and I do give a lot of good legal advice, and it's nice to see that my efforts are finally being appreciated. And I'm like reaching for my pen. Then, of course, he adds by way of explanation, you see, I've been a huge fan of yours ever since you argued the Hamdan case in the U.S. Supreme Court, referring, of course, to the then acting Solicitor General of the United States, Neil Katyal, who was my former professor of criminal law. And I thought, okay, this is just a one-off thing, right? Like, he confused me with the U.S. Solicitor General, but no. Over the course of the next few months, I kid you not, I could not walk from here to there in the Justice Department without somebody walking up to me and approaching me and just kind of striking up a conversation on the assumption that I was the Solicitor General of the United States. And so that happens to you a certain number of times, and you start to think, well, maybe I could be the Solicitor General. So actually, I developed this kind of plan, and this is one of my big regrets over the course of my legal career. I had this whole plan worked out, and I was going to kind of hide myself close to the SG's office on the 5th floor of the Justice Department and wait for Neil Katyal to exit his office and go to lunch or an appointment or something like that. And then I was just going to kind of stride confidently into his office and sit down at his desk and start signing stuff and wait and kind of see how long it would take for someone to catch on. And I am convinced to this day that I could have authorized all kinds of government appeals if I had done that.
Now that we've gotten through the identity theft issue, part of our program, that's like it's not lost on me that I'm an Antonio Diaz and I'm in the Miami office where everybody thinks I speak Spanish, and I won the Hispanic Man of the Year award last year. I'm not, of course, so we'll just keep going with that. Let's talk, so again, my world largely revolves around groups of states. And I think when we think about things outside in the more national news, we think about groups of states. Let's start, though, first about talking a little bit about the Solicitor General and taking care of things at home. So, I don't know, Amit, you want to talk a little bit about Florida, and what kinds of things do you have to worry about first at home before you think about things outside?
Sure. So I had been a practicing attorney for about 12 years before I joined the state. And for 11 of those 12 years, I had served in the federal government in some capacity or another. And so that was kind of the world that I lived in. And one of the huge differences when I came onto the state was just learning about state law issues and procedures. And I guess the big take-home message that I come away with is that state law issues, even though kind of for obvious and understandable reasons, they tend not to generate the sort of national media attention as, say, US Supreme Court decisions. But state law issues are unbelievably important and interesting. And on a day-to-day basis, they have an incredible practical impact on people's lives. And so the kinds of issues that we've been dealing with at the state, I could just give you two categories of examples that are very different from anything that I ever did in the realm of federal practice. One is there's a lot of state separation of powers doctrine that our office deals with. And I'm talking about kind of like horizontal separation of powers, about distribution of authority between the different branches of state government, and also vertical separation of powers, the distribution of authority between the state government and local communities. And so, for example, in the first category, we've had a whole series of cases about whether particular state statutes violate a state constitutional provision that's been construed to give the Florida Supreme Court exclusive authority to promulgate rules of procedure. And I see some eyes glazing over and people like, that does not sound interesting at all. And it's not a super sexy issue of constitutional law, but it does have huge practical implications. For example, one of the statutes I'm talking about was about adopting the Daubert standard for the admissibility of expert evidence in Florida trial courts. Another was a statute that purported to change the burden of proof that's applicable to proceedings in which a criminal defendant asserts stand-your-ground immunity in the context of a criminal prosecution. And so we've had all kinds of issues like that. We've had a lot of separation of powers issues about whether courts have judicially manageable standards for assessing certain state constitutional provisions. A good example of that would be in the last year, the Florida Supreme Court, by a vote of 4-3, upheld the state's public education system against a facial challenge. And that challenge was predicated on a state constitutional provision that guarantees an adequate system of public education. And so there, no matter how you come down on that particular case, you have a sense of kind of just how important state law doctrine is, that the constitutionality of our entire system of public education came down to one vote on one state court with respect to the interpretation of one constitutional provision. And then going back to the vertical separation of powers, we've had a series of cases about the validity of state laws preempting local regulation of various kinds, including local ordinances regulating, for example, polystyrene products, minimum wages, regulation of firearms and ammunition, that kind of thing. So that's been one kind of bucket of state law issues that we've been dealing with, is basically state separation of powers doctrine. Another really interesting thing that we've been dealing with that I never had any kind of exposure to in the federal system is ballot initiatives and proposed constitutional amendments. That's a huge thing in Florida, as some of you may know. It's kind of like now this is the way that we make law instead of passing legislation. Like people just try to get it directly in the Constitution. And so one thing that our office was involved in last year is determining whether certain proposed constitutional amendments that were proposed by a Constitutional Revision Commission were properly placed on the ballot that was submitted to Florida voters. And that was a huge undertaking. It's kind of a once-in-a-20-year enterprise, something that I had never worked on that kind of thing in federal practice.
Right. Andrew, similar sort of individual state issues?
Yeah, I think so. And I think a couple things that I'll mention. One is one that I suspect that Amit and a lot of other states deal with, is sovereign immunity. That it's an issue that until I got to this office, I'd never really thought about. But it's one that is vitally important to states and their sort of ability to conduct business and various things. And one, it's an issue that's sort of predates even the US Constitution, and then is sort of over time, the US Supreme Court has made various rulings on it, but you have this whole sort of separate state court set of issues surrounding sovereign immunity and the extent to which it applies in various states. In Georgia in particular, we've had a string of recent decisions. I guess I should back up. Georgia, like many states, has not just one constitution. They have sort of a series over time. Georgia, I think, is maybe on its 11th. And then there's sort of a set of 1991 amendments to that constitution that included some very strong language about sovereign immunity. And so our court has been grappling with, over the past few years, questions about how strong that really is, whether it really truly requires the legislature to provide express waivers anywhere that you want to be able to sue the state. And working through those issues has been sort of new and fascinating, and something that I had not really encountered until coming to this. The other is one that has gotten some national attention, and that's state constitutional rights generally. So Jeffrey Sutton wrote a book recently. I can't think of the name. Someone else maybe can remind me, but essentially arguing that state constitutions are sort of a unmined possibility of potential rights that have not really been explored. And in Georgia, as in a lot of other states, many litigants sort of come to court and there will be a parallel state constitutional provision and a federal constitutional provision, say the Due Process Clause or the Fifth Amendment and the state constitutional equivalent. And they'll just say, this is a violation of the federal constitution and the state constitution. And so neither the litigants nor the courts sort of think about, are there differences in how those rights apply? That's certainly changing in Georgia. We have seen our Georgia Supreme Court take particular looks at when litigants have raised it, does the state constitutional provision apply differently? The one example that comes to mind for me is a series of cases in the DUI context. The court a couple of years ago issued a decision about the Georgia constitutional right against self-incrimination that is different from any other state in the federal constitution, which says that it protects not only against compelled speech or compelled testimony, but also compelled acts. The critical piece there is that applies to, and they held that it applies to breathalyzer tests, right? And so they've had a series of decisions looking at how does this particular state constitutional provision protect these things? Do you get sort of attendant Miranda type rights that apply to that? And how does that work? So I think that's another area that probably a lot of states are dealing with, and one that I think in the future will sort of expand as courts look to state constitutions as their own documents that have a different history and potentially different meanings than similar federal constitutional provisions.
That's great. You'll forgive me being the old guy up here, where I think about the old song, "The Night the Lights Went Out in Georgia." Remember the line, it says, "Don't trust your soul to a backwoods Southern lawyer." So we won't, no aspersions to you, Andrew. It's okay. Loren, so Washington, D.C., right? All due respect that it's not a state yet, but you have probably one of the most interesting sets of issues that come up in your office, and the type of jurisdiction that you have to take on, in my mind, sort of the broadest group of things that will come up. Can you talk a little bit about the kinds of things that your office has to do and the breadth of that?
Sure. So, the District of Columbia, not being a state, serves kind of three different functions, right? We're a city. We are treated as a state for most purposes under federal law. We are also the seat of the federal government. And so the range of issues that the district faces really runs the gamut of kind of municipal to state law issues. So much like Georgia or Florida, we are litigating constantly large tax cases. We're doing issues of immunities. But then we're also doing a lot of work that is more traditionally housed within municipalities. So that is defending our police officers. It's state and local employment discrimination cases. And so then it goes all the way down to our administrative docket. I think that state SG's offices vary in their work depending on whether they have a state intermediate appellate court. So the District of Columbia, their local court system is the Superior Court and the DC Court of Appeals, which is our state Supreme Court. We don't have an intermediate level court, which means that there is a right of statutory review of all administrative agency litigation from agencies directly to the DC Court of Appeals. So that can be the $120 million tax disputes. It can also be the neighbors fighting over whether their fence is under historical protection. And so it really runs the gamut from the very, very big and kind of issues of first impression to the quite small. We once had one of our law fellows, someone who's a recent law school grad, working on a case that was literally worth $10. And it was somebody who put their trash out on the wrong day, and they were very upset by this, and they were like taking it to the top, And so it's, the work is quite interesting. We don't have the same, we have some of the same horizontal separation of powers questions that states have, in that trying to figure out, who has what authority in what space. But our sort of separation of powers questions are more, what is the district status vis-a-vis the federal government? Because since the 1970s, Congress has granted the district home rule, which is why I say we're treated like a state for most purposes. We have our own state legislature, we have our own set of laws, but at the same time, under the district clause of the Constitution, the federal government does retain full authority at any time if they want to step in. And sometimes they have, and sometimes they haven't. And so it's trying to figure out how the set of federal laws and the set of district laws can work together. Much like Andrew was talking about having state and federal constitutional provisions that speak to the same issues, we might have federal and state statutes that speak to the same issues. So for example, the Individuals with Disabilities Education Act, IDEA, is a big federal statute that governs nationally how the standards for educating individuals with disabilities in our public school systems. DC has an almost identical, but in some ways different set of state laws, and so people will often bring causes of action under both state and federal law, and then we'll have to figure out what relief is afforded where and in which forum. And so while we're not a full state, I think that the issues and the legal analyses really play out in much the same fashion.
One of the, I think sometimes when we look at issues, particularly with the states, we kind of think of states as being the same or ubiquitous in a way, and there's a critical path that each state has to follow, and geography matters, right? And even just listening to the three folks up here, each one's going to have distinctly individual issues. I'm even realizing the different issues in my change of geography. I was in Pittsburgh for a long time, in DC for decades, now down in Miami, but I was in a great conversation last night at a couple of the happy hours about all the mangoes in my backyard. So this is a great group to talk about mangoes and the things I can learn, though. So I'm not going to ship any of them out, but I'm learning a lot. I'm going to stay with Loren, though, for a second, because I want to dig a little bit deeper now on the fact, understanding that states are different. States have different issues that they want to focus on, and that you as Solicitors General need to look inward sometimes and make sure you're protecting the laws, defending the laws of that state. Let's talk a little bit about what people don't see, which is cooperation or lack of cooperation among the states on issues. Let's first talk about primary issues or important issues that a lot of the states might have joined together on. So I guess maybe let's, if you want to, focus on things where an active practice is seeking support from different states or amicus support from different states. Can you talk a little bit about that, Loren?
Sure. So I think it varies. There are certain issues that affect states uniformly. A lot of times if it's a state taxation power or a particular type of state regulation where you might see 49, 50 states joining onto one amicus brief at the Supreme Court. I mean, I think the recent Apple versus Pepper case was one that all three of our AGs were on, all three of our states were on. Then there are other areas that states build coalitions around on particular issues. So for example, DC with 10 other states recently brought suit to prevent the T-Mobile merger because our analyses showed that was something that was going to be detrimental to our consumers and to our workforce. And so that was an issue that across state lines affected similar states similarly, and so we all joined together to be co-plaintiffs in that suit. Then there are also issues that fall more along political lines. So there has been kind of with this uptick in state solicitors general, there's also been kind of a national movement of having attorneys general being elected rather than appointed. So when I came on as the deputy solicitor general, the DC attorney general was an appointed position and has since become an elected position. And that is a growing trend across the country. I think that is because state executive offices, the governor for most states, the mayor in the District of Columbia's case, are obviously wide subject matter experts. They might not be trained in the law, and so there's been this movement to have there be an independently elected and accountable legal officer in the attorney general. And so when my attorney general switched from being an appointed attorney general to an elected attorney general position, he ran on a platform. He had a party affiliation. So suddenly there was an injection of politics into what had otherwise been just a pure particularly legal office. And so as a result, my boss is, he's a Democrat. He is big in the Democratic Attorney General's Association. So he and other like-minded attorneys general, especially in this particular federal administration, are bringing suit against things that they find objectionable. So that is, travel ban, DACA, census. So those are more issues that take on a more political valence. That's not something, even though we see more AGs being elected, that's not something particularly new. When Ted Cruz, now senator, was the Solicitor General of Texas, he really started the practice, as did Jeff Sutton when he was at the SG of Ohio, in bringing together coalitions of then red states to fight against policies of progressive administrations that they did not agree with. And so I think depending on who is in power at the federal level, you typically have the opposite party at the state level banding together with like-minded states to bring challenges. But I think what's interesting is that we might be red state versus blue state on one particular issue, and I think guns is one where I'm never going to be on the same side of the V as these folks. But then you have cases where there are the same interests permeating through every single state or a large swath of states that don't split up along Democrat versus Republican. I think opioids is one of those issues. That is obviously a crisis at a national level, and the ways in which it has affected different states and different communities has no regard for who's in power. And so those are cases where you start looking at who's joining suit and who the bedfellows are, and you might not think that we have the same affinities, but depending on the issue, we really do.
You've heard you heard Jeff Sutton's name a couple times, who now sits on the Sixth Circuit. Jeff and I were partners together at Jones Day for a while. One of the things that has changed since Jeff was in private practice, one of the last things he was doing there was working as essentially counsel to the groups of states that wanted to jointly file briefs with the Supreme Court. Since that time, I think the number of state solicitors general have doubled, so that you now have state solicitors that are now attached to the state that are inside the Attorney General's office. The other thing that people, I think probably in this room know, 25, 30 years ago, state attorneys general were largely unknown. It cost less than $500,000 probably to run for attorney general if you were running for it. It will cost 20, 30 times that amount in most states now to run for attorney general. In every state, the AG's office is the largest law firm in the state. I think that's still true. And I will say the level of sophistication in particular areas has grown. The financial services sector is one of those, following the mortgage settlement. The number of people inside the office that have highly developed skills with regard to not only servicing, but also even securitization and other issues lies within the AG's office. I say that because the SG's office now, in all of those offices, there is a heightened demand for the best lawyers that can be found. And so when you look at the qualifications of these three folks, you're seeing really the best of the best, but also people that are now road tested and ready to go into the Supreme Court to defend their states and do it jointly on behalf of others. So don't think I was going to let red-blue fall to the ground. So let's go down that path just slightly and talk about a little bit about how that works. And so Amit, talk a little bit just generally. I don't want to know about specific issues, but how does that just sort of play out on the ground? Is that, do letters go around? How do you sort of look at issues that have some national significance in which there's going to be two sides to the story?
Yeah, it's a great question. It is, I think, pretty common now among state solicitors general for the state SG to be coordinating the multi-state and the amicus practice. I think that's true for all three of our offices. Now, the state SG doesn't make the ultimate determination whether to join a particular amicus brief or to join certain multi-state litigation, but is coordinating that process and making a recommendation to the state AG, who typically has the final say. And I guess, what I would say is, I think the model varies from state to state, and it varies from AG to AG. In Florida, our Attorney General. She came into office in January. She was a trial court judge for 10 years before she stepped down from that position to run for AG. Her dad is a federal district court judge in the Middle District of Florida. Her grandfather was a judge. So she is steeped in the rule of law and has kind of a palpable reverence for the rule of law. And I would say she brings that mentality to the job. And so when we have conversations about things like amicus briefs, typically the very first question that you're talking about is, who has the better view of the law on their side? And these do tend to get there are some controversial issues that come up in the context of the amicus practice and the multi-state practice. And I don't think anyone in this room would be shocked to learn that some really big questions of law, especially the ones that have to deal with kind of larger than life constitutional issues, there's a high degree of philosophical content to those issues. And sometimes that philosophical content will kind of typically sort of align itself along traditional party lines, not always. So there is that. But I would say that the vast majority of the work that our office is involved in is really kind of non-political in nature. And even with respect to the stuff that is politically charged, I think the value added that we bring to the table is to give the AG non-political advice. And that is to say you have a chief appellate litigator who's in a position to say, is it in the state's institutional interest to be joining this litigation or this amicus brief? That's how I try to approach my recommendations, because I know that the Attorney General has many better people who can advise her on the non-legal stuff. So my job is to advise her on the legal stuff.
Andrew, it's generally similar in Georgia. I mean, I had, in Georgia particularly, I worked a lot with General Owens and Thurber Baker when he was AG down here. Again, good lawyers, people that work together well with other states. Tell me sort of what you've seen so far in your seat.
What Amit describes as far as the process, both for multi-state amicus requests and potentially joining multi-state litigation, is pretty similar in our office. AG Carr has been very explicit that he is the only sort of politician, elected official in the office. The law department is not a political entity. And he views my role and I view my role in sort of, again, coordinating the recommendations for these particular joins as one that focuses on the legal issues. So, when we receive these requests, it is very much a question of what do we think is right legally, and then sort of just as important, where does the state's interest lie in this? Do we have a dog in this fight? Do we have a similar law under challenge? Are there reasons that we need to enter this particular litigation or join this particular brief to show support for a particular law or agency or something like that? So as far as the process, I think it is very similar in that way. Speaking to the sort of, you see these sort of red versus blue issues, I guess I would liken the array of issues and requests that we get into the Supreme Court's docket, which is that you see, all of these decisions coming out at the very end of the term. Those are sort of the big ticket items. You see red versus blue, but the vast majority of the issues in the Supreme Court are not partisan issues and generally don't divide along partisan lines. I think you see the same thing with all of the amicus requests that we get in. Many of them will not be sort of 40-state coalitions, but you'll get a group of 10 or 15 states who have a similar interest that they need to protect, or similar kinds of laws that they want to ensure that they're sort of defending. And so you see many bipartisan briefs in addition to maybe the more high-profile cases where you see sort of red states lining up on one side or the other. So for a defense lawyer, your world is incredibly confusing to me, and frustrating to deal with all of your bosses. Not all of them, but occasionally becomes very frustrating. And you've heard a little discussion already about the political side of that world, which again,
I used the word discipline before, and I do think the SGs, the Solicitor Generals, really need to be disciplined on what they do because they really are pushing the rule of law. But I do want to talk a little bit about sort of emerging type of issues that are coming through there. So I'll use a couple examples of where things are political or not. But when I started working on state attorney general work, the only organization who was out there for state attorneys general to sit around and talk to each other was the National Association of Attorneys General. About 20 years ago, you saw the breaking apart of that of a little bit with the formation of the Republican Attorneys General Association, RAGA, and soon after that, the Democratic Attorneys General Association. Now, I think it's pretty common for any major companies or interests that they get involved in various of those organizations, try to work in those. And a lot of the topics discussed at those meetings by the different states are public and available for people to see. And largely they serve as fundraising vehicles in addition to the policy-driven things that they do there. But you also find both of those organizations and together to become real cauldrons for ideas and innovation in trying to address social needs or others. And there becomes a tension then on how, if that affects private industry or companies or banking or whatever it might be, pushing up against whether there is the AGs are the right way to try to regulate it, whether legislature is, whether the courts are going to have a role in that, which again goes to your world. Somebody mentioned opioids, which, as I think many of you know, right now in Oklahoma, you've got a really incredibly important piece of legal work that's going on there. Opioids, by all accounts, may be the largest transfer of wealth in our history since the tobacco settlements, if things work as it looks like they may go forward. But it also is one where I think largely the states are not separated in wanting to try to address those issues by use of the strength of the individual state AG's offices. So, one of the things that comes up in that litigation, for example, is use of the public nuisance theory or more innovative kinds of things. Does anybody want to talk a little bit about how you go about evaluating new issues of law that come up? Because sometimes it may be your AG that wants to get involved, and they look largely at you and say, well, I want to do it this way, and each state will have a slightly different take on the law. So again, I don't know, let's take opioids. Any thoughts on sort of where that goes? I think, is each of your states in the multi-district litigation? I can't remember. In any event, give me some thoughts on what you see as sort of new emerging trends or things that the states are going to have to look at in trying to address new issues. And we don't have to talk about DACA, and I know those things are going to come up that are more public policy issues.
I think it's hard to talk about any one case just because we're coming at it from different sides, and those are active litigation matters. But I think when Tony's talking about RAGA and DAGA, you'll never see any of us at those meetings. Right. So I mean, there are, I think, some SGs that are brought on to be kind of adjuncts to their AG in a political way. I am not a politician. I am not elected. I hate politics. You did not see me at the running for office panel yesterday. Like, I believe in the law and the rule of law, and that's what I do. There are plenty of very brilliant people, my boss included, and the folks that he hires to do the political side that can give him input on that. So I don't see that as my role, and it's in fact a role I think I would be wholly incompetent to play. So when we're trying to evaluate whether we get into a case, it's, do we have standing? Is this the appropriate venue? Do we think we have the laws to really make this a robust case? Is this a case where we're better off going it alone, or is it a case where we should partner with other states that are facing this same issue? Because Maryland, Virginia, and DC have such kind of porous borders, a lot of times we're consulting with those state AGs and their SGs about whether where's the best place to bring suit. And so so if you look at a case like, for example, the travel ban, there were a host of states, typically states with Democratic AGs, that were interested in suing to push back against the executive order when it first dropped. And so, that was a situation where you had a lot of different states on calls, on emails, trying to figure out who was the best to be the front of this litigation, right? Who had jurisdiction, who had venue, who had the best courts? If we think this is going up to the Supreme Court, is it better to tee it up in multiple jurisdictions? If so, which are those jurisdictions? And so I think those are the considerations that as state SGs we are competent to give input on. But to the extent that gets fed into some sort of political sausage maker, that's when it goes up the chain to the AG and to his more political staff to take what we give them as, here are the rules and here's how we see the chessboard, and then let him make the final strategic call as between the multiple moves we think are possible in any given case.
Thoughts from Georgia or Florida? I know that was a careful question I tried to throw out there, see if anybody would bite. Loren gave, I think, the same answer that anybody would give on this one, which is these are real lawyers. And they, it's so ingrained in what they've done, and you can tell by their past. It's so ingrained in what they do that they're really fighting for the rule of law. They may have different takes on it and come at it from different ways, but the rule of law is critically important. So let's shift a little bit to a little bit more personal side of the office. We're all here because we're here for SABA, right? And we're talking about, I love the idea of rise and represent. I mean, these three folks are great examples, again, even with the diverse member on our panel, of just overcoming your Georgianness to become Solicitor General. But I do want to know, because I found that these offices are incredible places to try to get experience, to try to get exposure. And for people from our community, I just think an incredible chance to show off the talents and exhibit a little bit of our culture in there, which is, again, passion, persistence, ability to hang tough in tough situations. So I'm going to give me your thoughts on how does the SG's office or roles like this feed into the future of diversity and inclusion for our communities?
Well, I think it's been gratifying to see so many SGs coming from diverse backgrounds in recent years. Florida is celebrating the 20th anniversary this year of its SG's office, so it's a relatively new office. And I think I am the first kind of minority who's an SG, and that's something that I guess the way I think about it is it's a reflection of a good thing, which is that we live in a society in which your background is not should not, if our system is working properly, it should not be a barrier or an impediment to career advancement and to service. And at the same time, I guess I would say, I don't know that I could tell you that there's any decision that I would have made differently. It's kind of like my background is such an important part of who I am. My cultural heritage is such an important part of who I am, but it influences me in probably a million different ways. Some ways I'm conscious of, and some ways I'm not conscious of. And I think that, I guess the way I think about it is it impacts your life, but not necessarily in definable and predictable ways. And so in terms of how does it affect your decision making, there's not necessarily kind of the direct correlation between, well, we make this decision and it's because that's attributable to my South Asian ancestry. But I would say that there are a lot of, I think, South Asian SGs that we've seen in recent years. There's Mithin in Oklahoma, and we had an SG in New York, Preetha Bansal.
Right.
I don't know if that's kind of getting
that's right. And Loren, from a couple perspectives, there are 11, right, women SGs?
I think that's right.
10 or 11. I may get the number wrong. 10 or 11 women SGs. But give me your thoughts on it. I mean, you get to see a lot out of DC as well, which is and that is from a public service sort of perspective as well. There are a lot of people that go to Washington to be in public service, but you're also part of the state, the Washington. So thoughts on diversity and inclusion with the job?
So I think that state SG's offices are probably one of the most diverse legal environments you can have, and I think it's gratifying that there are, I think it's 10 or 11 female SGs. There are 2 South Asian AGs, there are at least 3 South Asian SGs. But I think particularly for women, Supreme Court and appellate advocacy is a field that has not been very open to women, especially women of color. I had a Supreme Court argument last term, and I was the only Asian woman the entire term. Not just South Asian woman, but Asian full stop, which when you start thinking about the demographics of the United States, it starts looking kind of crazy, right? But I don't think I would have had that opportunity to have a Supreme Court argument had I not been in a state SG's office or the federal SG's office. And I think that's just because the market for appellate litigation is very small. Thankfully, there are a lot of very accomplished South Asian advocates in it. You heard from a lot of them yesterday at the Supreme Court panel, but they are by and large men. And so I think, particularly being a female and a person of color, I think state government is really a place where you can have the same high level of opportunities commensurate with your credentials and your experience that you might not be able to get if you were just in private practice or even in certain offices within the Justice Department.
Andrew, you came up through what I think we're going to continue to see as a more regular path, right? You come out of law school, you're at the top of your class, you go and do maybe a Supreme Court clerkship or a circuit clerkship. Tell me about what you see as the pathways for sort of age, and then you decided to come home. Mm-hmm. Tell me a little bit about what you see out there for opportunities to get to levels of leadership for people that are, that we want to advise coming out of law school. I mean, I'm seeing now a shift, and maybe you guys are all seeing it, where people come out of law school, they work for a little bit, and then are doing clerkships. Mm-hmm. Certainly on the circuit level, even on the district court level, some doing public service, they'll go do a stint in an SG's office or an AG's office, something like. Any thoughts on that?
Yeah, so I think there are a number of things that people in solicitors general offices look for. Clerkships are obviously a good thing to have, right? They're sort of a valuable experience, and that's sort of one piece on a resume that's always going to stand out. But I think the path to this kind of office can be varied. Going out and finding, I guess I'll step back. The things that we look for that are very important are really good writers, creative thinkers, and people who care about public service, right? And there's a lot of ways to show that. If you go into private practice or a nonprofit and you find opportunities to write, that's going to get you a look. Clerkships, other ways of finding public interest opportunities. I think we're looking for bright people of all kinds who have who want something more than just going into private practice, that want to sort of serve their state and that have that drive to do that. And then I guess the other thing I would say to piggyback off of Loren, our offices, I think, provide an opportunity for experiences that you just can't get maybe in private practice at the same stage, right? So look at me, for example. I came out, I clerked, I practiced for a couple years, and now I'm in the Solicitor General's office and I'm arguing case after case after case, which is something that in private practice, clients aren't going to pay a 4th or 5th year or 6th year even to go do that. So I think it is maybe an underappreciated opportunity to get really interesting experience and serve the people of your state in a way that maybe you can't find in other places.
So we all have our personal stories, right, of what our parents wanted us to be and what we became. Of course, my parents wanted me to be a doctor, and I wasn't smart enough, and I went into the law. But forget about what your parents wanted you to be. If you weren't Solicitor General or you weren't a lawyer, what would you be? Let me say, Amit. I'd be a drummer, by the way, so just in case you're wondering.
What would I be? Well, when I went to college, I thought I wanted to be a research scientist. and I was going to double major in physics and biology.
So you've always been sort of nerdy then, just generally?
I'm not sure that's the word I would use. Well,
I mean that with all affection. Yeah, no, I mean that with all affection. No.
Yeah, well, I mean, I'm the kind of person that it was really hard for me to choose a career in the law just because I'm interested in everything that I read about, and every time I kind of see something or read about it, I'm like, I want to do that. Like, that sounds awesome. And my parents were really in distress for a long period of time. I mean, first because they realized I wasn't going to go to medical school, which was obviously heartbreaking for them. And then after that, I was working. Not only was I not going to medical school, but I was working as a production assistant at Book TV at C-SPAN in DC. So it's not even on kind of professional track, not pursuing a postgraduate degree. And they were really, at some point, they made their peace with this kid is not going to medical school, and how can we steer him in the direction of something that's otherwise socially productive and respectable. Right. And so after that, they were kind of making a case for a long time about going to law school.
Great. Andrew, other than wanting to be head coach of the University of Georgia football team, you would have been?
You're pretty close. So I think in an alternate universe where I had grown 6 to 8 more inches, I would have been a major league pitcher. That was my aspiration. And then I realized I was, senior year of high school, and I was still 5'7". that probably wasn't going to happen, and so it was sort of the legal path from there on out.
Yeah.
Loren?
If I weren't a lawyer, I would be a lawyer. There is nothing else I have ever wanted to do, much to the great dismay of my parents. When they were giving out the awards at lunch, I was shocked by how many of you folks knew each other growing up. I knew no lawyers growing up. Everybody was a doctor, right? Everybody else in my family is a doctor. All of my cousins are doctors, as my parents remind me frequently. So yeah, I mean, early on, I think my parents just had to get with the fact I was going to be this great failure in life and just go down the path of the law. But yeah,
great.
Sadly, I've never wanted to do anything else.
I feel sad in a little bit, but I'm so glad you are where you are. Do we have a couple minutes for questions? Are we okay with that? So let's just open it up for a few questions. I think there's a mic around if we need it. And as you see, no questions are out of bounds. We'll see. Any question? Oh, there's one back there. You're getting a microphone. Wait. Not yet. Kind of, we can hear you. Yeah. Oh, wait, there we go. I didn't hear it.
The question was, I think.
There it is. We got you now. Go ahead.
So yeah, I was just wondering what you thought about
While they're thinking of an answer, introduce yourself and tell me. There we go. So just another solicitor type down here. So thank you. Was that enough time to come up with an answer?
It seemed like you had a view on that. Andrew.
Sure, I can take that one. I guess a couple things. First, I think Judge Sutton's view that those constitutions are independent of the federal Constitution as textual documents, and that we should interpret them as such it's just accurate, right? I mean, they're different texts with a different history, and to the extent that undertaking the act of textual interpretation leads to different results vis-a-vis the federal Constitution, I think that's entirely appropriate, and there's certainly a sort of fertile ground for sort of figuring out what the law is in a particular state. As for how lawyers can sort of use that to their advantage, I think it just comes down to if there's a lawsuit that you're thinking of bringing, or if you're thinking about different ways to vindicate particular rights, just don't forget about the state constitution, right? And in court and in your papers, you separate those arguments and you look at those things independently and raise them at each stage to make sure that you're preserving those issues. So I don't think it's rocket science, but I do think it is something that, for the longest time, because they often have similar language and one was patterned after the other, maybe in certain instances, they've sort of been ignored. So, generally I agree with, Judge Sutton as far as that goes. Now there's also sort of the normative question about sort of how aggressive should you be in using them and finding them, and maybe that's a different question, but those are my thoughts.
Yeah, if I could just
Yeah,
follow up on that for a second, because it's a great question. And as to the second part of what you talked about, how can we as advocates use this line of argument that state constitutions independently have meaning from the federal constitution? We use that all the time, and especially in the context of federal litigation. And usually it comes up in the context of, we sometimes will provide the court with a kind of 50-state survey, and the upshot of which is to say, look, states are adequate to the task. They're up to the task of addressing these difficult and debatable questions of social policy, and they're coming up with innovative solutions. So you, federal court, don't need to come up with a heavy-handed, kind of one-size-fits-all federal constitutional solution to a difficult and debatable question of social policy for 300 million plus Americans in all 50 states. And to the extent that you can find kind of state laws or state constitutional provisions that have been judicially interpreted in such a way as to protect certain interests that maybe the folks on the other side of the litigation are trying to get at by creative reinterpretations of the federal constitution, that's an argument that I think will resonate with a lot of courts. Now, query whether the argument should be that the way that states should innovate is via judicial interpretation of state constitutional provisions rather than state legislation. And that's a subject that reasonable people can disagree about. But I do think that putting in front of a federal court hard and fast empirical evidence that states are dealing with this problem and you don't need to step in, that can be a very powerful line of argument.
Loren, any thoughts?
Nothing to
add. That's, and good question. Look, I think that these are going to continue to be important questions that the states are going to struggle with, primarily because of the emergence of new ways of approaching issues, whether they be social or otherwise. Other questions? Right there, okay. Perfect.
Sure. So I think most of us applied. It is not a political position. We do serve at the pleasure of our Attorney General, so we don't have any, I think, fixed term. We, I think, all hope we will be there as long as our AGs are there, but that depends on whether they like and continue to like what we are doing. In terms of just how we found the job, so I think it's actually a funny story, so I'll be a little longer, I'm sorry, Angela. But in law school, actually, Amit and I went to law school together. We were a couple of years apart. But I had a friend who was the head of the Federalist Society, and I was the head of ACS. And 8 or 9 years later, he had become the Deputy Solicitor General in West Virginia, where his entire mission was just to sue the Obama administration. That is what he went to West Virginia to do. He had great fun doing it. And so out of the blue one day, he shoots me an email, and he says, hey, if I were liberal, I would like this job. And he sends me the job description for the deputy SG in DC. And he says, all of my friends are conservative, but you, so clearly you should do this, and then we can fight against each other forevermore. And so I thought, oh, hey, cool. First I thought, does DC have a Solicitor General? Because I had worked at the US Solicitor General's office, and I knew that position, but I didn't know that DC had one. And so then the more I poked around, the more interesting it seemed. And so I sort of took a gander on applying for the job, went through the process, and not my current boss, but the prior AG hired me to be the deputy. And then a few years later, I was elevated to be the SG. But I think the moral of that story, especially for those of you that are more junior in your career, is be open to opportunities. Like, I really didn't know that there was a job called the Solicitor General of the District of Columbia until this random email found its way into my inbox, and it is the greatest job that I have ever had.
Could I answer the question really briefly with an anecdote? So the short answer to the question is that Solicitors General are typically, and certainly in Florida, are typically appointed by and serve at the pleasure of the Attorney General. I can also tell you an anecdote that will give you a roundabout way to kind of illustrate that point vividly. And that is, shortly after I got appointed, I was at home, and I walked into my study, and I found my then 6-year-old son sitting at my desk, and he was writing on a piece of paper, and he was just completely concentrated. And I asked him, I said, what are you doing? What are you writing? And he said, well, I'm making my list for Santa of the things that I want for Christmas. And I was like, okay, that's interesting. So I looked over his shoulder, and I'm kind of looking at this very long list. And number 1 item is like some obscure toy that I'd never heard of. And number 2, it says Solicitor General. And I'm like, okay, that's interesting. What's that all about? Why does it say Solicitor General? And he says, well, I want to be the Solicitor General when I grow up. And so I'm thinking, wow, like my kid, he kind of respects and admires me, and he wants to be like me, and this is great. And then I made the mistake of asking him why. Like, why do you want to be SG when you grow up? And he says, because I'm a kid and everyone's always bossing me around and I want to be the boss when I grow up. So I tell him, I'm like, well, I don't want to burst your bubble or anything, but actually I'm not really the boss. I work for the Attorney General, so she's my boss. And he didn't say anything, and I could see that he was crestfallen, right? But he didn't say anything, and I thought, okay, he'll get over it, and we'll just leave it at that. So I leave the room, and I come back a little later, and my son is not there, but the piece of paper is on the desk. And I look at it, and number 2 has been crossed out Solicitor General, and in its place is Attorney General. Right, so, that's the answer to the question.
Okay.
Same answer.
Okay.
Only thing I'd add is anyone who thinks that they might be too young to be able to be in the Solicitor General's office or unit or anything like that, you're probably not, right? The prevailing model really is to find great young attorneys and snap them up before they get on partner track, frankly. So always looking, and I think it's sort of a fantastic opportunity.
If we have a minute, I would like to just say one thing to follow up on that, and that is to illustrate that point also. Like in my office, one of my deputies graduated from the University of Florida, undergrad and law school. He clerked for 2 years on various federal courts, and then he came straight to our office. So, no big firm experience or anything like that. His first federal court argument was a huge First Amendment case in the U.S. Court of Appeals for the 11th Circuit, litigated against a little-known appellate attorney by the name of Paul Clement. Right? And so for those of you who know Paul Clement, former Solicitor General of the United States, by any standard, one of the most phenomenally gifted appellate advocates in the country today, that was his first appellate argument. And he won in a big First Amendment case that had the potential to go all the way up to the Supreme Court. So if you're looking to work on, if you're the kind of person that you're interested in constitutional law type issues, if you're interested in kind of the big law issues that we read about in the newspapers every day, if you want to do public service and government service, I would say absolutely consider looking at your state SG's office, because you will get opportunities the likes of which just cannot be found in private practice. And the world of appellate litigation in general and constitutional appellate litigation in particular, it's a really hard niche to break into. Like the U.S. Solicitor General's office is a fantastic office. You had people like Pratik and Cannon, who we all listened to yesterday, who are just kind of unbelievably brilliant. And they're able to break into those shops. But for the rest of us, it's a really, really hard practice to break into. If that's the kind of thing you're interested in, you consider your state SG's office. Now, your chances of getting that kind of job and working on those kinds of cases just went up by a factor of 50, right? So it's something, if it's something that you're interested in, I would say talk to all 3 of us after this, and we'd love to tell you about what it's like and how you might consider applying for a position like that.
Great. So 2 things. In your app, your SABA app, the CLE code is SABA NC, SABA NC. Number 2, let's thank these great folks for their presentations. Have a great day.